Hello and welcome. Good evening to the speaker for today, CA Avinash Ravani sir. Good evening to all the participants. I welcome on behalf of the Committee on Commercial Laws, Economic Advisory and NPO Cooperative Sector, I CA Rishikesh Badwe. Kindly welcome all the participants and today's webinar speaker, CA Avinash sir, for this webinar. So as you all aware that the topic for today's webinar will be everything about the partnerships, the drafting of deeds, the care to be taken about drafting and the partnership business. How is it to be carried? We have a distinguished speaker for today, CA Avinash Ravani sir. Welcome, sir.
Thank you.
So, as per the protocol, I'll just kindly welcome all the participants as well as the chairman and vice chairman in absentia. Chairman CA CV Chitra sir in absentia, as well as Vice Chairman CA Prakash Sharma ji. I welcome them also in absentia. And today's speaker CA Avinash Ravani sir. I would kindly introduce the speaker. CA Avinash sir, qualified as Bachelor's in Commerce as well as FCA and DISA. He is a member of the institute since May 1993, and his firm Ravani and Company since 1993, practicing in the field of direct tax, audits, and corporate law matters. He is a member of various study circles and study groups of WRC of ICI. He has delivered lecture in various study circles of WRC, SIRC, ICI, BCA, the Chamber of Tax Consultants, that is CTC, and other corporate forums and organizations. He has delivered more than 600 lectures on the topics of income tax and company law. He is also the visiting faculty for corporate houses and IIM. He has also contributed to various articles for study groups and websites, including ICI journals. He has also been a core team member of ICI in handling e-filing help desk on issues on uploading, filing of various e-tax audit reports, e-IT returns mandated under the IT Act. He is also the special invitee member of the Direct Tax Committee of ICI for the year 2018 and a study group member of the committee since 19. Presently, he is the study group member of the Direct Tax Committee of ICI on preparation of implementation guide on changes in Form 3CD. So with this brief background, I welcome CA Avinash sir this webinar and kindly invite him to deliberate on the issues on partnership. Thank you so much.
Thank you, Rishikesh sir, for the kind invitation, and also I'm grateful to the Committee of the Commercial Laws for giving me this opportunity to speak on this subject. Today's subject basically is related to the Partnership Act and partnership drafting, and we'll be covering basically specifically related to the partnership law, and we are not going much more beyond the Partnership Act. So basically, when we deal with the partnership, so today's basically when we see that we have learned basically when we were studying during our exams that partnership is a relation, because when two or more persons come for a business, it is called a partnership. And basically what happens, am I audible? Because something is, I'm not able
Yes, sir.
to
Yes,
hear
yes.
one
You are
minute.
perfectly audible, sir.
Yeah,
Please
okay.
continue.
So
Yeah.
basically, if we see the Partnership Act defines Section 4, deals with the definition of the partnership, where it says that two or more persons who have agreed to share the profits. So basically, the reason behind the partnership is that person should have come together to share the profits. And the business should be carried on either by one or acting other a person who is acting on behalf of any one of us. So basically, this is the definition of the partnership under the Section 4 of the Partnership Act. Then It is binded by an agreement. So there should be an agreement between the parties. Then only there will be a partnership. Otherwise, no. So back there, there should be agreement, and that agreement should be for the sharing of the profits. So the purpose here is the person should come together. There should be an agreement. The agreement may be an oral agreement or can be a written agreement. Now, one question may come over here: how it can be an oral agreement? Because Partnership Act says that the agreement can be an oral agreement. Now, in this earlier because in the earlier days, because Partnership Act came into the Partnership Act came into effect in the year 1932. At that time, with all the agreements, there was no people were relying on the words of the words, and there was at that time the words of the person had the value. So oral agreements were also valid. Until now also the act has not been changed. So it says that even if today, if two persons agree that they agree that we want to do the partnership, it is still valid under the Partnership Act. And a person, that is, suppose if two persons agree that we will be doing the business, and if one person does the business and another person another person is there who doesn't do anything, then also that partnership is valid. So other person will be considered, the person who is doing the business will be considered as an agent on behalf of the other person. So we have means basically the concept of a acting partner and a sleeping partner. That is the criteria. Then and can be implied that the person is the agent. Then it can be formed for any lawful purpose. The business of the partnership can be only for the lawful purpose. So this is basically what is said in the definition of the partnership. So partnership can be formed only for the lawful purpose. It cannot be formed for the unlawful, illegal businesses. So this is the four purpose for which the partnership business can be formed. So this has to be kept in mind. Second thing, this has been clearly defined in the case law, which is under Lakshmi Narayan Modi versus Commissioner of Income Tax, where it has been stated that definition of the partnership was clearly mentioned. This is confirmed by this said case law. Now coming to the Partnership Act 1932. 1932 means because this act has been in existence in the British by another British law, and there has been no modifications since then, because slightly it was monitored because it is a state law. And from 1947, India got the independence in 1947. So the act has not been amended since then. Only minor amendments have been made as per the requirement by the different states. The act defines the partnership as between the relationships who have agreed to share the profit, which we have already discussed. Now it lays down that the essential elements of the partnership, such as agreement, should be there for the sharing of the profits, carrying on the lawful business, number of the partners. Now here also it says the partnership should have a number of partners. It should be more than two partners. Mutual agencies should be there, and the liability of the partners should be unlimited. So Indian Partnership Act always says that the limited liability of the partners will always be unlimited. So there cannot be a partnership, cannot be with a limited liability under the Indian Partnership Act. And for that, if you want the partnership for a limited liability want to be formed, then they have to form a limited liability partnership, which will not be under the Indian Partnership Act 1932. It will be under the LLP Act, which is not governed by this Indian Partnership Act 1932. It will be governed by the LLP Act, which will not be registered under this Act. Then Act of the Parliament that governs the Partnership Act in India. So even if it is covered by this Act is of the governed by the Indian Partnership, it is governed the full Indian Partnership Act 1932 governs full India. But we may have state-wise, given the powers has been given to the different states. And it came into force from 1st October 1992 and has been amended several times. And it has given the powers. The Act has provided powers for registration. So it's what it says that the Act provides for the registration of the partnership firms and the rights and obligations of the partners of the partnership firms. The right has been given to the partners under the said Act, and it extends to whole of India except Jammu and Kashmir. Now, question may come over here that since India had this Article 370 has been 370A has been abolished, so this should be made applicable to Jammu and Kashmir also. But if you see the constitution which has been amended now, even after the amendment of this constitution, this Indian Partnership Act 1932 has not been made applicable to the Jammu and Kashmir states. It is applicable only to whole of India, but except Jammu and Kashmir is still been excluded from this. For Jammu and Kashmir, we have a separate Partnership Act under the Jammu and Kashmir Act. There is a separate act for applicable for the Jammu and Kashmir, which is on the same line under the Indian Partnership Act. So still, this is not applicable despite Yeah. So there are limited external element, and then there is a sharing of risk and rewards. This is basically the risk and rewards are being shared with the people. In other words, when the two people come together, the risk and rewards are also being shared with each other, and the succession also becomes longer because the proprietor in proprietorship, when the proprietor something happens to the proprietor, the proprietorship immediately becomes dissolved. And here the succession is much longer. And even if in the case of a partnership firm, suppose if any partner expires and if there is any clause in the partnership, then it can be business can be taken much longer level, because the successor of the partner can become a partner in the partnership firm and the business can be done. Then the legal structure, the changes are also possible in the partnership firm, because you can draft the deed accordingly, and based on the deed drafting, you can give the shape and the changes shape accordingly in the partnership firm, and you can have as many structures, legal structures possible in the partnership deed. So this can be kept in the mind, and specifically when you draft the partnership deed, you can draft the deed in such a way that you can have as many possible structural things in the partnership deed. You can give the responsibilities, you can give the roles and roles to the partner, how you can modify it, how you can change it, how you can structure it. All things are possible in the partnership form. So these are the basically advantages of doing the partnership, doing the business in partnership. Now coming to this, who can be a partner in the partnership firm? Individuals definitely can be a partner. Even a partner of a firm, an LLP can be a partner. And because directly a partnership firm, another partnership firm cannot be a partner in the firm, but a partner on behalf of the partnership firm can be a partner. That is mandated. An LLP, a designated partner on behalf of a partner LLP, can become a partner, because corporate bodies are allowed to become a partner. Trustees on behalf of the trust can become a partner. HUF cannot be directly become a partner in the firm, but through Karta, HUF can become a partner. That can be done. That is allowed. Companies definitely can become a partner in a partnership firm, but then there are conditions, certain conditions. That is basically when a company wants to become a partner, they have to ensure that the necessary approvals in the board meetings are being taken, and they become the partner in the partnership firm. Then who cannot become a partner? That is, certain persons are barred from becoming a partner in the partnership firms. That is, first is a person who is not of a sound mind cannot become a partner in the partnership firm. Then minors are also actually basically some minors are allowed. Those minors are allowed to become a partner, but only for a specific extent, because they are allowed to become a partner for sharing the profits up to certain extent. And we will discuss in the next slide that is why partners are not allowed to become a partners. Then persons who are disqualified from entering into a contract by a court of law, they are not allowed to become a partner. Then insolvent person, basically a person who is declared insolvent by the court of law, is not also allowed to become a partner. These are the persons who are barred. Now section 30 of the partnership act says that minor category for certain extent can become a partner in the partnership firm. And it says the minor cannot become a partner in the firm, but they can be admitted for the benefits of the partnership firm with the consent of all the partners. So all the partners should give the consent. They are liable for the acts of the firm, but minor cannot be personally liable. Has a right to share the property and profits of the firm as agreed upon, and may access and inspect the firm of the accounts. If the minor decides to serve the connection in the firm, then they can sue the partners for an account or payment for the share of the profit for the profits of the firm. Because basically here the restrictions here is given that they can be a partner for the partners for the profit only. A partner, their rights and liabilities as a minor continue until they become the partner. Basically, what happens that a minor, when he is admitted for the purpose of partnership, when they attain the majority, then they will decide whether they want to continue or they don't want to continue as a partnership. So a period of 6 months has been given to them. Within that 6 months period, they have to decide whether they want to continue or not. Now, what happens is, suppose within the period of 6 months, they don't decide. They don't decide that they want to continue or not. They keep silent. So if they keep silent, then automatically it is decided that they have become a partner in the partnership firm. So they will be treated as a normal partner. So that thing has to be kept in mind. So secondly, when the partnership firm is registered, then what happens? When a minor person becomes a major person, then they have to inform the registrar that this person has become major, and they have to get this either partnership deed has to be modified, and they have to file certain forms for giving the effect of this change in the partnership. Then, if the minor does not to become the partner, their rights and liabilities continue until they give the public notice, and after which the share is not liable for any acts of the firm done after this notice. But they are entitled to sue the partners for the share of the property. So this is what Section 30 of the Partnership Act says. This is what Nagindas Ramdas versus Dalpat Ram Icharam case law is there, which gives the detail. Now, partnership basically it is a contract. Under Section 4, it says that it is a contractual relations between two or more partners. It is based on the mutual trust and confidence. Now, every relationship, either it be a partnership or any other relationship, it is based on the mutual trust and confidence. And it says any business which starts or any relationship starts, it is between mutual trust and confidence. Whenever this mutual trust and confidence break, the relationship always breaks. It is not a legal entity distinct from its partners. It is a legal because partners and partnership form, because whenever the business starts, everything is very good. And when the things are good, everything is taken in a good stance only. And partnership basically always gets dissolved on the death, insolvency, or retirement of the partner. It says that it's a dissolution of the partnership. Means any basically this Section 4 says in such a way. When we come to the last 2 or 3 slides, then we'll discuss this point. What is the difference between these? Why it is said as dissolution? And jointly and severally liable for the debts of the partnership fund, because basically it is an unlimited liability. When it comes to unlimited liability, all partners are jointly and severally liable for the debts of the partnership. So this should always be kept in mind. So it is an unlimited liability, all partners are liable. Then for this purpose, there's was in the case of Bagri Textile Corporation versus Additional Commissioner of Income Tax, there was a liability was there, and it was held that tax liability was not paid. So it was held that all the partners has to pay jointly in liability all. Now, kind of partnership can be formed for many purposes. There are 3 or 4 purposes are there. This partnership can be for with regard to the durations and with regards to the extent of business. In this case, with regard to the duration, it says that partnership at will, because generally all the partnerships generally are at will. So till they have this type of partnerships are there where there is no fixed period has been defined. So till the business means, it is said that as per the will of the partners, till their will is there, the business will continue. Once they decide that they don't want to do the business, partnership will get dissolved. Certain partnerships are there that is for a fixed period. That is the provision is they come together for a certain type of fixed period. That's basically when they are for a fixed contract period, also for a contract period, etc. They come together. Once that contract is over, generally this type of partnership happens in case of a construction contracts or in case of builders, etc. They tie up their hands for a particular project or else. Once that project is over, they may that project is over, the partnership gets over. With regards to the business also, now suppose they come together for a certain business also. Suppose now one business has come, they have got some project, some business, that is some business has come for particular area or something that if they come for that certain adventure or some business has come. So for that purpose also they form a partnership. Then general the constitutor for business in general, it is called a general partnership. So these are the 4 purposes for which the partnership can be formed as per the Section 6 of the Partnership Act. Then type of partners. Basically, here it is says that there are active and ostensible partners who has become a partner by an agreement, who actively participates in the conduct of the partnership firm. Basically, we tell it as a active partners. Then sleeping partner, that is who is a partner by an agreement but does not actively take part in the conduct of the business. That is called a sleeping partner. It's just either invest in the business of the partner or in such a way. Nominal partner is just the person who is lending his name without having real interest in the business. No interest, no share in the profit, no investment, does not participate in the, however, this will be liable to third parties. who will become such type of partner. But this type of people are there just for the namesake, they become the partner to give the goodwill to the name of the business. Then partners in profit only. Such type of persons are entitled to share in the profits and not to the losses, but they are liable to third parties for all acts of the profits only. Then incoming partners. New partners in already existing not liable to the acts done by the before his admission, because new partner is already in the existing firm but not liable to exit. Then outgoing partner, the outgoing partner is who leaves the firm continues to be liable to the parties for all act done until the public notice is given. So whenever the person who leaves the partnership firm, it is always advisable that he gives the public notice that he has left the partnership firm, because it may be such that if he leaves the partnership firm and if he does not, if the third public persons who knows him that they are partner of the firm, and if such notices are not given, he may be held liable. That is always, basically it is advisable that whenever the person retires, the public notice should always be given in the newspaper, so he is not held responsible in future if certain things unforeseen happens in that firm. Partners by holding out, that is basically estoppel, which says that when a person hold himself as a partner, because generally it is seen that it does this, that many people said inform third party that he is a partner in the partnership firm. So he introduces them as the partner to the third parties, but actually is not a partner. He is so the partner by estoppel, and when the third person deals keeping on the faith on such partners, then he will be presumed to be a partner. He will be treated as a partner and he will be liable to that creditors as a creditor. If any losses happen, then that person will be held to be he will be presumed to be have acted as, means he is the third person who deals with them, treating them as a partner, and if any losses happen, then that person will be held responsible. So that is a partner by holding out. So these are the basically types of partners. Then coming to the essentials of the partnership deed. So whenever you are drafting, any person who is drafting the partnership deed, section 5 has to be kept in mind. So section 5 says that agreement is mandatory because it is a contractual relationship, and it is based on the agreement between the partners. So the agreement also always should be there. Though the Partnership Act says that oral agreement is valid, but it should always be presumed that a written agreement should be there. Now what it says that oral agreement, though it is valid, but subsequently it has to be written. It has to be in writing. So what is agreement? Oral, if it is written, oral is there, some written should be there, because third person should know that what it is agreed by between the parties. So somewhere it should be there, it should be written. And it should specify the rights and obligations of each partner, including the capital contribution, the duration of the partnership, profit sharing ratio. It is mandatory. So it is these are the basic requirements, that is capital contribution, profit sharing ratio, duration of partnership. These three things, this should be mandatory, and in the partnership form, this is the basic requirements. Coming to this sharing of profits, section 13 says that profit sharing ratio is essence of the partnership, because people have come together to share the profits, and partners must agree that on the proportion of the profits which may be shared, it may be equal or it may be unequal, and it shall not be said that it will be decided in future. It may be when there is a change in the partnership profit sharing ratio, then there should be a reconstitution. That will be then that should be a redrafting of the partnership bid subsequently, but it has to be a part of it. Then business, what business they are going to do? The business should be a lawful business. That also should be a part of the partnership bid, and cannot engage in any illegal or immoral activity. So that is also required. These all are the case laws wherein it was the Gokul Das, Jamna Das. These are the case laws related to the Partnership Act. This will be helpful to you. Then number of partners, basically there should minimum at least 2 partners. Maximum partners is 50 for the business, for any business, and 20 for the banking business. The Companies Act 2013, however, allows up to 100 partners. Mutual agencies. Each partner is an agent of the other partner. So suppose if a person, your other partner who is there, it is absent, and any third party comes and deals with other partner, then he is treated the other partner, the partner who is dealing is treated as the agent of the other partner. So each partner is the agent of the other partner. That also is a part and should be forming a part of the partnership. It should be mentioned in the partnership deed. Acts of the partners bind themselves and other partners, even if the act is done to carry on the business of the firm. So that is the requirement, which is mutual agency. Section 18 says liability. Section 25 says it is unlimited liability. Partners are jointly and severally liable for the debts, obligations of the firm. In case of default, creditors can recover the entire amount from any partner regardless of their profit sharing ratio. So if one partner, even though the profit sharing ratio is fixed, if one of the partner is unable to pay the debts of the other, the same they can be recovered from the other partners. So that also has to be kept in mind. So these are the various case laws relating to these sections. Then partnership deed can be oral or written. Name of the firm is mandatory. Name of all the partners should be there. Nature and place of business. Date of commencement, duration, capital contribution, profit sharing ratio. What will be the criteria for admission and retirement? Should be agreed. Rate of interest and capital, drawings and etc. Because this is as per the requirement of the Income Tax Act. Because if this rate of interest on capital etc. remuneration is not mentioned, then Income Tax Act will not allow you the depreciate this allowance under section 40B of the Income Tax Act. That should be kept in mind. Then settlement clause in case of dissolution, because this is again mandatory, because there are definitely disputes, or in case a dispute arises, or in case of this dissolution is to be done, how dissolution has to be done, that should be a mandated part of the partnership deal. Then if any salaries or commission has to be given, because there may be some partners who are kept only for this means there may be this working partners or sleeping partners. So working partners may be given some salary, some person who may be kept as maybe made a partner and who will be doing this sales part. So he may be kept on given the commission on the sales. So that should be, if it is there, such mentioned. And in case of any fraud, if it is considered made by any partner, then what should be what should be done? If it is required, that should be mentioned. Then he is able to have the partnership deed in writing to avoid future dispute. It should be duly stamped in accordance with the Stamp Act. Where the partnership deed contains the immovable property, the instrument must be in writing, stamped and registered under the Registration Act also. That is basically immovable property instrument must be in writing and stamped under the Registered Act, under the Registration Act, because that property which is there under the proper this is what the Act says. Advantages of registration under the Partnership Act: it provides a legal recognition to the firm and the partners, enables the firm to sue and to be sued by its own name and enter into the contract. Because unregistered partnership, there are certain disadvantages. Provides for settlement of disputes to the courts, provides for creation of a separate entity that is distinct from its partners, then enables the firms to various benefits for others incentives. Then basically what happens that registration is mandatory. Registration is, though it is said that it is not mandatory, it is mandatory. Then section 56 registration of partnership says that registration of partners, the act gives the power of the state to exempt the provisions of any act or state or by the notification. Because state government, each state has a separate partner, because whether some of the states have exempted the partners. Now, for example, state government of Rajasthan has issued a notification in the official gazette that the provisions of the act will not apply for the Rajasthan. Thus, Rajasthan will be outside the purview of the act. Now, Indian Partnership Act 19 provides for the appointment of the registrars. Registrars mean the separate registrar will be there for each of the state, who will take care of the registration of them. So the state government has the power to appoint the registrar of firms. The registrar of firms is considered as a public servant under the within the meaning of the section 21. The state government of Gujarat appoints Mr. Raj. Suppose, for example, the state government, section 57 says that this under section 57, the state government of Gujarat appoints Mr. Raj as the registrar of firms in the state of the Gujarat. The state government also defines the areas within which Mr. Raj shall exercise his powers and duties. So this is within the provision. The appointment will be done. The powers will be defined. So what will be the powers of that registrar is defined by the act. So appointment is done by them. How the registration, that also is defined by the, will be defined by the, governed by the registrar who is appointed. How he has to, how the registration has to be done is specified in section 58, which deals with the application of the registration of the forms. So it says that by sending the statement in the prescribed form with the prescribed is within the location of the business. So basically, for each type of registration, the form has been prescribed. Normally, for each of the states, the forms has been, the forms are on the similar lines, similar lines, and there is a prescribed for each registration. Now it says that the form should have the following details: that the name of the firm, place, principal place of the business, name, and any other name and in the place business can be. Basically, it is the additional place of the business and date of joining of each of the partners. These are basic criteria which is required to fill them in each place, each form for the registration of the partnership form. The name along with the permanent address, the duration of the form duly signed by all the partners or authorized. The form should not contain the words such as emperor, empress, queen, emperor, etc. implying such sanction, a patronage of the word except the state government. The except in the state government. So these are the restrictions that you cannot use the words of empress, queen, etc. So though there is a restriction that name approval in the name, you cannot use such name. So now what the thing is that in Maharashtra, there are certain restrictions which has been given, that is in such case some trademark if it is registered. So if such trademark is registered, so when you go for the registration, these trademarks, these firms are not allowed for registration. It allows that, it forces you to change the trade name. So you have to be very specific and very particular. Now suppose one more such established firm name is there, which has a very good place now, very good name. And if you go and keep the same name and you want the same, it is in the same line of business, then it will not be, it will not, the registrar will not grant you the registration on the same name, because it is having a same registration or some trademark is there. You should have been, though it is permitted, but the same is not allowed. So it has to be taken very care has to be taken that you don't use such type of names, and because there may be some if the trademarks are registered and if such names are being kept for registrations, then in such cases it may happen that you may land up in some litigation problems in future. So this type of names should be avoided. Though such names may look familiar, and it should not be in the name of some political parties or such type of names. That should be also. Second, section 59 says once the registrar is satisfied that the provisions of section 58 have been complied with, he shall record and make the entry in the financial statement. If now what happens if the forms is not registered, then the liability to initiate a suit of the civil court by the partner firm or its co-partners against the third party. The third party can file a suit against his partners or firm lack of relief partners in offsetting the claim. So there legal action, prohibition of aggregation of relief parties, prohibition on the aggrieved partners from legal actions from the other partner. Now what happens is, suppose if the person, the partnership form is not being registered, third party can sue the partners or the partnership firm, but partnership firm cannot sue it. The 100, even that limit for this, that in excess of 100 rupees, the case cannot be filed. Then third party legal action against the firm cannot be taken. That is not allowed. So this is the biggest shortfall is there. So this is the effect of non-registration. So now what happens then? Suppose if I am somebody I have done some business with third party, and the third party is not paying me the money, and my firm is not registered, then I cannot file a suit against the third party. Now suppose the third party, I'm doing the business, I'm owning my trademark also, and third party is using my trademark, and third party is illegally using my trademark, and my firm is unregistered, then that firm can file a suit against. I cannot file a suit against it because I am not registered. So these are the disadvantages against them. So this should be taken very care of. So it is better advantages that form is being registered. Now coming to section 29 about the transferring. Now basically what the thing is that when the partners business are being done, the business can be transferred to third person. The partner can transfer his right to the third person. That is allowed. But in that case, partner can transfer his share to the third person. But according to this, the transfer partnership deed should mention that the partner's business, the person who receives the partner share is not entitled to interfere in the conduct of the business and or inspect during its continuance. But in that case, partnership deed should provide such clause in there. If the clause is not there, it cannot be done. But however, the partnership section 29 says that if the transfer is entitled to receive the share of profits by transferring the partner and accept the amount agreed upon by the partners, the act has already says that it has the right, but only for the transferring the profit. For profit transfer, it is allowed. If the firm is dissolved or the transferring partner ceases to be the partner, the transfer is entitled to receive the share of assets of the firm to which the transferring partner is entitled, and the court may determine the shares on the date of dissolution. Basically, this is related when a partner expires or ceases to be the partner, then the partner's transfer is the share of that person for a limited purpose is transferred to the transferee and is entitled to receive the profits. Basically, it is related to that clause. And this was defined by section Bharat Dyeing in the case law of Bharat Dyeing and Manufacturing Company Limited versus CC. Now, incoming and outgoing partners. Now, there's how the incoming partner will come to the partnership firm and how the outgoing partner, what will be the settlement of that, that also should be forming a part of the partnership. Now, section 31 to section 34 deals with this clause. Section 31 deals with introduction of partner, this how incoming partner will be can be brought in. Section 32 deals with retirement of partner. Section 33 deals with expulsion of partner, and section 34 deals with insolvency of partner. Now, one thing it should be taken into precaution will be taken if any of this clause, if they are not mentioned in the partnership deed, then act will prevail. So if the partnership deed says that if there is mention of the partnership deed, then the priority will be given to the partnership deed. And if the partnership deed doesn't specify any of this clause, then the partnership act will prevail. Introduction of partners shall be with the consent of all the partners if it is required. For consent of partners of all partners is required, can take only place if there is agreement between the current partners and provisions section 30s are followed. New partners not liable for the act done before the admission. This is the three criteria. Business basically section 31 says. For retirement of partners, retirement of partners can be by three ways. That is consent of all partners in accordance with the agreement, or by notice to all the partners is served, the notice has to be given. So if there is partner, notice has to be given. Can be discharged from any liability to any third party for acts done before their retirement by an agreement by them or such party and the partners of the reconstituted firm until public notice is given to of the retirement continues to be liable. Person can be given by any of the partners. So see, in the case of partnership firm, therefore the retirement, if the partnership deed says that there should be a notice should be given, written notice should be there, that may be 1 month, 2 months, 3 months, what is agreed by the partners. But if it is not agreed, then this condition should be satisfied. Partnership, this condition will, section 32 will come into picture. Expulsion of partners. Expulsion of partners can be, so partners cannot be expelled by a firm by any majority of partners except in the good faith of powers conferred by a contract between the partners. The provisions of retiring partners in this case will apply for both point number 2 and 3. That is basically what we discussed in the case of retiring partners. Then insolvency of partner. Basically, if the partner becomes insolvent by a court of law, then from the date of the order, he will cease to be a partner. If the firm is not dissolved by the adjudications of a partner as an insolvent under the contract between the partners, the estate of the insolvent partner is not liable for the act of the firm, and the firm is not liable for any act of the insolvent partner done after the date on which adjudication order is made. Section 35 to 36, basically liability of the estate of the deceased partners. That is, if the partnership agreement does not state that the firm will be dissolved in the event of the partner's death, then the estate of the deceased partner will not be liable for any act of the firm done after the partner's death. So till the date of the partner will be liable after the death of the partner. From the date of the death of the partner is not liable. For example, now suppose if say A, B, C are partners in the firm, and there are partnership agreement does not provide for the dissolution of the firm, and upon the death of the partner, if A expires, his estate will not be liable for any acts done after the firm's death, because his liability ceases from the date of his death. He is liable to the partnership firm till the date of his death. So the date of his death, his liability discontinues. So he is not liable from the date of death. This is what section 35 says. And the rights of the outgoing partners to carry on the competing business, because once the partner says that, retires, then how, after what is decided between the partners, so at the time of dissolution, in the dissolution date, it is to mention that what has to be done. What is agreed by and between one, that will prevail. But what the act says that he may carry on the competing business and may advertise it provided, but he cannot use if it is not decided, then he cannot use the firm name or represent himself as a partner. He shall not solicit the client of the firm. That is what section 35 says. A partner may make an agreement with the partners that he, on ceasing to be a partner, he will not carry on the business of a similar that of the firm. That is what it is, because non-compete agreement may be made, because that depends on how the partners decide. It is not mandated. That act does not say that section 35. So this act does not say that you cannot pressure this mandated. But if it is agreed by it, then it is depending on the partners what it is decided. So suppose, for example, now outgoing partner of the firm sells the car. He may start a business that selling the car, but he cannot sell the car in the same firm name and carry on the same business. And he cannot solicit the custom of the persons who are dealing with the firm. But generally, it is not possible, because this is full market is there, so it may not be possible. So that is possible. That is, so it has to be taken. What is decided, that will prevail. Now coming to section 37, that is what is the rights of the outgoing partner in certain cases. That is to. So member of a person, now suppose dies, ceases to be a partner. Suppose in the form is there and a person dies or he ceases to be a partner, then the surviving or the continuing partners may carry on the business, will be carrying on the business with the property of the firm without any final settlement of the accounts. Then the outgoing partners, his estate is entitled to the share of the profit made since he ceased to be partner. So because what happens, if the business is continued, so till his share is given, he is entitled to receive his shares. The share of profits may be attributable to the use of the outgoing partner's share of property of the firm, or to the interest at the rate of 6% per annum on the amount of his share of property in the firm. If there is a contract between the partners that gives the surviving or continuing partners the option to purchase the interest of the deceased or the outgoing partner, then that option is exercised. Then the estate of the deceased partner or the outgoing partner's estate is not entitled to any further share. So basically, see, one thing is here is that deed or act, what is agreed, what the section says. You can directly take these points directly for drafting the partnership directly from the act, or directly from the what is agreed. So when these all things are agreed at the time of making the partner or the drafting the partnership deed, it will be very easier. That doing the business will be much easier, because what happens when the business which are done at a time of doing the business, relationships are very good, things are very good, and when by doing the business, when the relationship, when the business is done, because you have seen the partnership forms, for so many partnership firms are there. They are doing the business since last 100 years. Business are being done. The relations still are very good. So these things happen, and there are many partnership firms. Then within 2 months, 3 months, the relationships are such that they are not able to do the business for a single day also. So relationship gets worsened day by day. So these things comes into picture. So there are always two sides of a coin. You never know which side of the coin you're going to be there in fall in the future. So that you have to consider, because basically when all things are written in a good way, so it is better that you decide it much better. Now A, B, C are given from A decides to leave the firm, there is no final settlement of accounts. And A and B firm continues to use the A share of property and the profit, then A and are entitled to share of also. Still the final settlement is done. If you are using the share of this property, you are not given the final settlement, then you are given the right of the profit, the share in the profit is required to be given, because if the share of this rights is been given, the settlement is done, then you don't have to give any further rights. Revocation or continuing guarantees given to the firm or the third party, because now what happens, suppose company bank, now in case company partnership firm has borrowed money and they may have taken a loan, that the third party person may have taken a guarantee also from for a business. In that case, what may happen? The continuing guarantee given to the firm for a third party in respect of the transactions of the firm is automatically revoked as to the future that there is change in the constitution of the firm. Section 38 says this. Then this means that if the partnership changes in any way, as by the admission or retirement of a partner, any continuing guarantee given to the firm or the third party is revoked as to any transaction that occur after the change. The directive, whenever reconstitution happens, continuing guarantee shall stand revoked. You have to give a fresh guarantee. Means there anyway, as the admission, retirement of partner, any continuing guarantee given to the firm or third party is revoked as to any after this. This is what simple scenario section 38 says. This was held in the case of Bank of Bihar versus Damodar Prasad and Sons. Coming to the last leg, that is dissolution of the firms. Section 39 to section 44. The dissolution of firms, basically there are three things. Dissolution of firms between all the partners of the firm is called dissolution, because now when everything basically dissolution of firms happens in three ways. When the partnership firm is at will, so in that case dissolution will be by giving the notice. In case of a dissolution of firm, when it is for a purpose specific business, when that business gets over at that time, dissolution will be, that business has been over, the dissolution will be completed, and business is completed, so the firm has to be dissolved. When it is for a specific adventure, when adventure has got over or that specific purpose has got over, the firm will get dissolved. So in that case, automatically on completion of that project or object, that the purpose get completed, the business firm has to be dissolved. So now coming to section 39, it says that section 40 says the dissolution by agreement. So at the time of dissolution always has to be by way of an agreement. It may be dissolved with the consent in accordance with the agreement contract with all the parties. Now, whether one question may come, say if a partnership which has been formed, which is by oral partnership, whether then in that case also dissolution has to be by way of agreement, written agreement should be there. Yes, definitely. Written agreement has to be there, because there is no such in any act in the law for entire partnership act. There is nowhere it says that dissolution can be by way of an oral agreement. It cannot be with the oral agreement. So partnership cannot be dissolved by way of an oral agreement. It has to be by way of a written agreement. So dissolution will always be by the written adjudication with all of the partners. So it has to be signed by all the partners. So adjudication of all the partners or all the partners. If it's an insolvent partner, he has to sign the agreement. By happening of an event in case of unlawful or carrying out the business. So any business it is carried on, if that business becomes unlawful, then also the business it has to be compulsorily dissolved. Now, suppose if some business was there, business is there, suppose they have been carrying on some lottery business, which was there earlier, it was legal business. Now, that lottery business suddenly became 2-3 years back, then become illegal business. So now that lottery business became illegal, so that was become unlawful business. Now they had to dissolve that business, online lottery. Then again, that business become legal subsequently, because after GST came and all. So in between, for something, some purpose, that business become illegal. So that these things happen. So if they become an event, by happening of such event, if it becomes unlawful, then that has to be dissolved. Section 42 deals with the dissolution of account. So because whenever there is a dissolution of firm, the account has to be prepared. The account has to be prepared till the date of dissolution and has to be prepared, and the account has to be settled. So if it is constituted for a fixed term or an expiry of that term, then the account has to be for that firm, carry out a certain undertaking, completion of the project. Or if there is a death also of a partner, the account has to be repelled till death, the death of that partner, and the profit or loss, etc. Whatever is that, the transaction has to be completed till that date. Or if there is an insolvency, that date of insolvency. In case of a partnership, which is that will, then the dissolution will be that by giving a notice till the that date. So notice will written notice has to be given. Once that notice is given, then the dissolution will happen. And suppose the court has given, matter has gone to the court, then court may order a dissolution. Section 44 deals with the dissolution by the court. Then if a partners, at what time why the court will order, section 44 deals with this, their partner has become of an unsound mind, partner or other partner is suing, is permanently inconforming his duties or guilty of misconduct. So in these three criteria, court will order dissolution of the firm. Now coming to the other forms of how this partnership form is distinguished in the other corner. So legal status, if you see, partnership form does not as a such we see the legal existence is definitely, though it has the legal entity, if you compare the partnership, company has a separate legal entity. Partnership form is in between. So in between the company and in the sole proprietorship, our company has a separate legal entity, but partnership firm as such does not have any legal entity. Though partnership, in case of partnership firm, each partner is a agent of other partners. However, in case of a company, a member, a shareholder is or a shareholder is not an agent or a member is not an agent of other members. Distribution of profits here in case of a partnership firm is distributed among the partners as per the profit sharing ratio. But in case of a company, there is no such compulsion that a profit has to be distributed. The company can definitely accumulate this profit, transfer to the reserves, and these profits can be utilized for carrying on the business. But here it will be credited to the partnership firm, partners capital account, and it cannot be restricted that this firm cannot, the partners cannot withdraw it. So this is the biggest shortfall here. Liability, definitely in case of partnership firm, it is an unlimited liability, but in case of private limited, in case of limited companies, limited by the shares, liability of shareholder is limited. But in case of certain companies, in certain case, the liability of the partner company, in case of a company, can become unlimited in case of certain cases, because there are certain criteria. If it is unfulfilled, then liability of the partners company can also be made unlimited in the Companies Act. Transfer of shares, share in partnership cannot be transferred with respect without the consent of all the partners. But in case of a private limited companies, if there are limited companies, yes, shares can be transferred and they are easily transferable. You don't have to do these alterations every time. Only you have to just fill up certain forms and all. But definitely there is a criteria which is given in the articles. You have to follow that criteria. Registration definitely is mandatory now, and compulsory registration under the Companies Act is also there. Winding up is definitely easier in the companies, easier comparatively in the partnership form, is very easier than comparing comparative to the companies, because in compulsory, it is compulsory under the Companies Act. You have to either go for strike off, either you have to go for voluntary this winding up with the NCLT, etc. That is there. Number of membership partnership firm, minimum 2 partners are required, maximum 50. Under the Companies Act, it allows to up to 100, but in private limited companies can go up to 200. That is there. Duration of existence, unlike the contrary to the death, because retirement insolvency may result in dissolution, but companies definitely enjoy much more perpetual succession. Then creation, definitely easier. Partnership deed is by drafting a deed, you can definitely start the business immediately, but here it is definitely compared to go the HUF. If you see the HUF, you is a success family business. In case of HUF, by birth only it comes into existence, you don't require any deed, but definitely now the issue has come that many people ask for the deeds and all, but definitely there is no such deed requirement actually in case. Death of a member in case of partnership firm ordinarily leads to dissolution of the partnership because it happens to a reconstitution. And here, in case of a death of a member, does not rise to reserve, it is a family business which continues on. Management, all the partners are equally liable to take part in the partnership. Generally, in case of HUF, it is with the Karta, who is the governing member of the family. All the rights are vested with the Karta, who is the elder member of the family, becomes the in charge of the business. Authority, every partner can bind this from the whether there is Karta is the whole and soul in case of HUF. Liability is unlimited, definitely, and in case of a Karta, yes, so and the co-person are liable only to the extent of the shares in the profits in the case of HUF. Partner can file the suit against the firm for accounts provided, etc. Also seek only and joint HUF, where really members are only can ask for the accounts of the business, but only Karta is accountable, cannot go for business and all this. Sharing the business is defined by virtue of agreement. By case no co-person has a definite share. Everything is on the hands of the Karta, and his interest is a members co-person's interest is fluctuating one, and is capable of being enlarged by the death of the member. So this is basically distinguished from the organizations. Now, certain issues are there that basically, can a partnership firm become a shareholder in the company? This is biggest discussions. That is, issues are there certain for discussion. That is, firm can become a shareholder in a company or not, because these issues come because generally what it says that Indian Partnership Act 1932 or the Companies Act 1956 or 2013 does not answer any question, but department circular, that is circular number 4 of 72, says that they cannot, partnership firm is not a legal person, so they cannot become a shareholder in a company. However, a partner can become a shareholder in a company and can hold the shares on behalf of the partnership firm, and definitely can comply with the requirements. So we can do, the partner can hold the shares on behalf of the partnership firm. That is permitted. Residential status of the partnership firm and its taxability, that is definitely one of the biggest, whether partnership firm, section 2 of the 6(2) of the partnership, this income tax act deals with the residential status, that is, firm will be treated as a resident in India if the control and the management of the partnership firm is resident in India, and if the all control and the management is of the partnership firm is situated outside the India. Basically, if the person, basically the partnership firm is earning income in India, majority of source of income, 6(2) will come into the picture. So you have to see the residency status based on section 6(2) and comply with this requirement. And partnership firm can be treated as a citizen of India or not, because a partnership cannot be treated as a citizen of India, because definition of a person under the deals with Citizenship Act 1955. Partnership firm is not a legal person and not a citizen, as to claim the fundamental rights granted to the citizen under the Constitution of the India. So these are the basically another issue. Then, can a partnership firm called an illegal association? So it is said that any association or partnership or a company contravening section 11 of the Companies Act 1956 is called an illegal association. An illegal association is under this section is, however, not an association for illegal purpose. Basically, what happens that if the company law says that more than 10 or 20 persons, unregistered persons, to carry on the business or association in India, does not, because if they become illegal or they carry on unlawful business, then they become unlawful, but it cannot be treated as such as an illegal association. So first, for merely that the partners exist more than capacity, it cannot be treated unless it carried for the illegal purpose. Then only it can be treated as illegal. But there is no such thing. Another question which comes into mind, whether a husband and wife can enter into a partnership valid business or not. That is one of the questions which had come. So basically, an individual, they are natural persons, and natural persons are eligible to become partner in the partnership firm. They may be husband and wife. So there is no such restrictions that can prohibit a husband and wife from becoming a partner into a partnership firm. And there is other, even in case of this has been held in the case also valid in case of Krishna Floor Mills versus CIT 1962. This case law is there, where it has been held that a partnership firm which was formed by husband and wife and the wife's brother, where it was held to be valid. So it is there. And what is the right of the female members of a HUF to become, whether the rights have female member has the right of the HUF to become a partners in the firm. Now suppose if a person, HUF is a partner in a firm and there is no male member in the family, so whether the female member can become a partner in the firm. Female members of HUF are also competent to become the partners in the firm of the partnership. They cannot be a karta. There is no bar for her to represent her as the HUF as an agent. There is a case law that is CIT versus Banek Industries. Hindu is not competent to become a manager of HUF to enter into an agreement of the partnership in a representative capacity. In this case law is there, but definitely she can be a member, but she cannot be they cannot create a competent to become a partner in the firm. They cannot become a so they cannot be a karta, but there is no bar to represent her as an HUF. Then it is said that there are two differences between the registration of the partnership deed and the registration of the firm, because everywhere it is stated that registration of the partnership deed and the registration of firm. These are the two different. What is the difference between the registration of partnership deed and registration of a partnership firm? A partnership deed can be written on a stamp paper and can be registered with the office of the sub-registrar, because any document which is registered, a partnership deed is required to be registered with the registrar, sub-registrar's office of each state, because you have to pay the stamp duty on the agreement as per the stamp act, and you have to get this registered. The registrar will verify whether the proper stamp duty has been paid. If any stamp duty deficiency is there on the deed, then definitely you will be liable to pay the deficiency in the stamp deed, and they will register it if it is in accordance with the partnership deed, state partnership, and they will register. So registration of deed does not mean the registration of forms. What it says that Act says that registration of forms will be registered following the procedure as which is provided in the section 58. Though the procedure is the same only, there is no such difference in the same. There is no difference between the procedure in the registration of partnership deed and the registration of firm. The certificate which is received, it says that the partnership, when the final certificate, you submit the document to the registrar, sub-registrar, registrar will accept the document, and the final certificate which is received, it says that the firm is registered. So final certificate which is received, which will give you the certificate. When the certificate is received, it says the firm is registered. The final certificate, when it is received from the registrar, it says that the firm is registered under the registry with the sub-registrar. Can a partner of a firm dissolve the partnership? Yes, partners of a firm can dissolve the partnership. There has been if the partnership says that he has the right to dissolve the partnership with consent of all the partners. Section 43, in case where the partnership is at will, he has to give the notice in writing to the partners that his intention to dissolve the firm, and he has to follow all the procedures what is there under the act, and by following the procedure he can definitely dissolve the partnership firm. That is can be done. Then again it's saying what is the dissolution of firm and dissolution of the partnership firm partnership. There is again the difference between dissolution of the firm and dissolution of the partnership. Now it says that dissolution of firm means that the breaking up or extinction of the relationship which is subsisted between all the partners of the firm under the various circumstances as contemplated by the act. A partnership firm can be dissolved only in accordance with the manner prescribed under the act. Dissolution of partnership is a case where one or more partners retire from or become incapacitated from acting as a partner due to death, insolvency or insanity or partnership. in relationship with the partner is dissolved. Means basically what happens, so if one of the partner retire, resigns, etc., then when there is a reconstitution of firm or when there is a change of firm, it says that dissolution of a firm. It has become basically reconstitution of firm is termed as a dissolution of firm, and entire firm, when it is a totally partnership firm, when all the partners retire and the firm is totally dissolved, then it is called as a dissolution of a partnership. This is the basic difference. Now, when you are doing the business, there are certain shortfalls because in partnership also certain shortfalls are there. Partnership has unlimited liability, the restriction in the number of partners, and it is not seen as a legal entity as a law, because whenever it is seen as a business, when you see as a partnership firm, only one person is seen as a central figure. This is the biggest advantage. When you start doing the business, a person who is seen as a partner figure, he is seen as a central figure. He is representing all the partners, and when he becomes a central figure, at the most he is representing, he's become the icon of the figure, and in at the last, this is the biggest disadvantage. What happens that he feels that he is the whole and soul of the business, and because of him the business cannot run. And because of this, from there starts the disputes in the partnership. And after certain extent, when the business turn, there is a trust dispute. Because each people try that now something, the person who is doing the business, the trust, there's a distrust which starts beginning, and this distrust results into dissolution. And there are certain business restrictions also, because certain, when you do the business in the partnership, you cannot do certain businesses which are restricted under that. You cannot, certain businesses like money lending businesses, etc. There are certain restrictions, that business restrictions are there, that you cannot do the stock trading businesses, etc., because you need permission from the it's not the stock trading business. Money lending businesses are there, RBI related business, There are certain businesses require permission from the Reserve Bank of India. Banking businesses are there. These type of businesses are not permitted under the so these are the shortfalls are, because when the capital requirement is too much, then that type of businesses cannot be done. Then while dissolving the businesses, that by doing the businesses, when you dissolve the business form, you have to be very specific that while doing this dissolution attempt, while dissolving the business, while drafting the deeds, dissolution also you have to be very careful by at the time of dissolution. Draft the deed properly. What will be the what will be the in that deed drafting? What the partners, when the partners are what assets are being transferred, when the assets are, specifically when the immovable property is there, when the immovable property is being distributed to the partners, see that the person who is being given the immovable property, the deed for the dissolution is properly drafted, and the power of attorney is properly given to the partner, and the registration deed is of the property is being done. Because all these things will matter much later on, because when after the dissolution is being done, this may happen, such things may happen in future, that each partner may not lend a signature in future, especially in case of a dispute which may happen. So this will be creating a much more problem. I think I have tried my level best to cover whatever things which was best possible to do. Thank you very much for giving me this opportunity, and I have tried my level best to deal with this subject. Now I've tried to cover all these things which are possible. Thank you very much. I think whatever questions are, I can take the questions which are available. Yeah, please. LLP versus partnership is better. Basically, partners LLP, you see, LLP is the advanced version of the partnership. LLP is the advanced version of the partnership form. One thing is it is a corporate version of the partnership form. And what type of business basically you want to see, that will define. And when you are doing the business in the partnership, you have the option that this is basically a startup, and a person who doesn't want to form a company and who wants to do the business in partnership and in the corporate form, for them purpose LLP will be better. And you have the option. Suppose now the person is starting a business, and if he's starting the business and he's just doing on a trial mode, and if that business becomes successful, definitely he has the option that he can later on convert it into a partner LLP. And the conversion from a partnership to LLP is also possible, and that can be done very easily. You can convert partnership also into LLP. You can convert partnership form into a private limited company. That also is possible. So basically, see that I would always recommend that your deed drafting will serve while doing the business or while drafting the deed. Take proper care that all these things are covered while drafting the deed. That will help you much while doing the business. Specifically, and at the time of registration also, because you've seen that registration also, people are preparing the partnership date, but they are not registering. And then whenever there is a reconstitution, or when there is a change in the address of the partners, also the things they are not registering with the registrar of homes. You have to say that they are registered it, because significantly when the changes happen, because there are very huge penalties for not complying with the requirements of the registrar of homes. To be very careful and very by doing this compliance work also. Partnership can buy a real estate property. There are no such they think that there is no such restriction that they cannot buy a real estate property. Please mention the I to be disclosed in the profit and loss appropriation account and the maximum amount extent possible. Basically, see, we have this topic today is not related to the income tax purpose, but definitely we have the formats of what is therefore we have a defined format for the profit and loss account and all items to be disclosed. Disclosed in the standard format has been defined by the institute. Or ICI has come up with the format of the profit and loss account. Wherein it has been given everything. You can just refer to that. Guidance note is related to guidance note has come for the non-corporate for as SSEs. You can just refer to that. Wherein all these details have been given with suitable explanations. You can just refer to that. Okay, fine. Then we shall we conclude it? Okay. Thank you very much. Already, and I'm very grateful and thankful to the committee for giving me this opportunity. And thank you all for the patience hearing.